for the entire manufacturing process. They can't give you minimum wages, they can't give you safety standards, they can't regulate the unions, they can't do any of that. All of it, 100% of that process is unconstitutional if you correctly interpret the Commerce Clause. The loading dock, when they put the cars on the big trucks, if that truck is going to cross the state line, Congress's jurisdiction starts at the loading dock. When that truck gets to the car dealer in Florida, they bring it down from Michigan, gets to the car dealer in Florida, and they unload the car, Congress is over. There's no jurisdiction over the dealership. There's no, it can't dictate the wages, the hours, anything to do with the car dealership. It's on that truck. While the cars are on that truck, they can regulate interstate commerce, mainly so that the states don't erect trade barriers, so that Florida prefers cars coming from South Carolina manufacturers as opposed to cars coming from Michigan manufacturers. That's the sole goal of the Commerce Clause. And you simply rewrite a sentence. The Commerce Clause gives the Congress the power to regulate shipping, and nothing related to shipping, but shipping. It is a very easy fix. The Department of Labor goes away. The Department of Commerce, basically, except for the FAA, goes away. And, well, actually, that's in a different department. But anyhow, the FAA can stay. And there's a very, very few things. Obamacare came, they tried to get it under the Commerce Clause. And John Roberts, who I wish would resign from the Supreme Court so he could run for office, so I could make a donation to his campaign. I'd like to give him 30 pieces of silver for his campaign. They actually used the General Welfare Clause, rather than, in which they said, the power of Congress to tax and spend is constitutionally unlimited. We can fix the Commerce Clause, we can fix the General Welfare Clause. 90% of our problems with the federal government go away. If we give members of Congress, members of the state legislature, standing to challenge the use of our military power in undeclared wars, we eliminate the undeclared war problem. I believe that the United States should go to war when our nation is threatened. We need to have a strong, robust military. But I believe that that's a decision of the nation through our elected representatives in Congress. It's not supposed to be the decision of one person. If they attack us, we attack back. We don't need anything to do that. But when we're going to go to Iraq or Afghanistan, we weren't being attacked at that moment by those nations. Those could have been legitimately in our interest. Perfectly good decisions. But we got to do the right thing in the right way. And the right way to go to war is for Congress to declare war. We need to do that. We can fix that. We can fix other problems that our country has been having. But we've got to fix the Supreme Court too. How are we going to do that? Well, the Supreme Court has fallen in love with international law today. In fact, I've written three briefs in the Supreme Court arguing against the use of international law for domestic purposes. One of them involving cases out of Florida, the juvenile life imprisonment without parole. My lingo is the LWOP case, the life without parole cases. And I filed a brief on behalf of 18 members of Congress, the Sovereignty Caucus, that argued that the constitutionality of Florida's law should not be judged by international law standards, but by the historical meaning of the Eighth Amendment only, and not by international law at all. The Supreme Court actually discusses my brief. They didn't like it, but they discussed it anyway. And they didn't like Amnesty International's brief. They split the difference in the middle. But nonetheless, the Supreme Court does like international law. The European Court of Human Rights is a modern functioning court. In an administrative sense, it works just fine. Like the Supreme Court of the United States, I'm not real partial to its decisions, substantive decisions, but it's a functioning, perfectly appropriate body that they know how to process cases. They have 46 countries, they have 46 judges. Every nation appoints one judge for a specific term. Most of the cases in that court are assigned to a smaller panel. I think the number is 9. And they draw the panels at random. And so most of the cases are decided by a randomly chosen panel of 9 judges. If all the judges want to hear a case, in fact, there's a standard for deciding that, and it's a minority of the judges can decide, and I don't know the exact number, but I think it's approximately, if 30% of the judges think that the whole panel needs to hear a case, they don't hear it in sitting down and have an oral argument kind of sense. They review the paperwork, and they make a decision, just like the federal courts of appeal do in this country. And so you can have, in fact, that's how we can do it in the Supreme Court of the United States. We have 50 judges on the Supreme Court. They're appointed for an 8-year term by the states. My preference is by the state legislatures. I don't really want the governors doing it. I think state legislatures would be the right place to do it. And you can operate a court just that way. If we did nothing other than make sure that we have people on the Supreme Court who didn't all go to Harvard or Yale, we would have accomplished a great deal. Every single justice on the Supreme Court of the United States today went to either Harvard or Yale, either undergraduate or law school or both. And if you want to know what's wrong with the Supreme Court, you can start with that. And if some of them went to Florida State and Gonzaga like I did, and University of Washington and other places, it's going to be better. 8 years and they're gone, that's going to be better. And when the states are the locus of power, when you take it out of the Washington, D.C. power cabal, we change it forever. We change the power of how the judges get there. We'll change our ability to protect liberty. How are we going to do this? And why is this the right path, and why is it safe? The arguments against the safety of doing this all stem from what I call defamation against the Constitution of the United States, or defamation against the Founding Fathers. I was in a debate recently in Oklahoma where the person I was opposing argued, and he's a very conservative person, a good guy overall, but on this he argues that George Washington was just like the statists of today. I'm sorry, I don't agree with anybody who accuses George Washington of being a statist. Shame on them. Shame on the people who are defaming the Constitution of the United States. You all heard it because we were all trained at least almost all of us were trained in public school history. And public school history has been lying to us for a long time about the truth of American history. And they've lied to us about the Constitution of the United States. And it's time that we learn the actual truth of how we got the Constitution of the United States. You've all heard that the Founding Fathers disobeyed their instructions and were supposed to only amend the Articles of Confederation, but instead they enacted a whole new document. You know why that's false? Because they were never told that was their job. Because you know who said that, who they quote? They're quoting Congress. Congress under the Articles of Confederation. They falsely call them the Continental Congress because they don't really know American history for people to say this. They're the Confederation Congress. There was the Continental Congress before we had the Articles of Confederation. Then there was a Confederation Congress under the Articles of Confederation. And then we have the current Congress under the Constitution. So we've had 3 different kinds of Congresses in the history of the country. The Confederation Congress did not call the Constitutional Convention. On February 21st, 1787, they endorsed the convention. What's the difference between the endorsement and the call? Well, there's a lot of differences. First of all, look at the Articles of Confederation. The Articles of Confederation didn't give the power to anybody to call such a convention. So where did they get the power? They got the power because the states had residual sovereignty. And if the states wanted to get together and talk about something, states could get together and talk about something, if they agreed to do so. And who set the topic? The states set the topic. Now 10 states said this for the topic. 7 of them, by the way, named their delegates, gave them their assignments, gave them their credentials before Congress endorsed it on February 21st, 1787. So the idea that this came from Congress, you just get a timeline out and mark out who said what when, you can figure this out really quickly. All 7 states that acted before Congress did said that their delegates were to do this, and I quote, "render the federal constitution adequate for the exigencies of the Union." That doesn't sound like they did anything different than that to me. That's what they were told to do. After Congress endorsed it, and by the way, Congress's endorsement said, "It is the opinion of Congress that it is expedient to hold the convention." And by the way, the time and the place that they named had already been specified by all 7 states. And before that, it was suggested by the Annapolis Convention. And so it officially came from the states. And so the 7 states said that was their goal. After Congress endorsed it, 5 more states named delegates, gave them their power. 3 of those said exactly the same thing as the first 7. 2 states, Massachusetts and New York, basically copied the language used by Congress. Congress said 2 things. They said they were to render the federal constitution adequate for the exigencies of the Union, just like everybody else said. But they were saying solely for the purpose of amending the Articles of Confederation and altering the Articles of Confederation. Well, altering is a big term. And James Madison in Federalist 40 goes through the details of even those 2 states. So only 2 states out of 12 that participated used the Congress's formula. 10 states, and what we know about anything, 2 states can't dictate to 12 states what the rules are. Every state controlled its own delegation, because every delegation was essentially ambassadors. And if the states thought their ambassadors were violating their instructions, it was incumbent upon the states to recall their delegates. And you know how effective instructions to the states were? The Constitutional Convention came to a screeching halt because Delaware's ambassadors or delegates were told they could not negotiate away the one state, one vote rule. And that led to the Connecticut Compromise, where we created 2 houses. Because of the instructions given by the state legislature of Delaware to their delegates, the necessity was there to create the situation where we had the House, where there was population, we had the Senate, where it's one state, one vote. Equal representation in the Senate was a result of instructions given to the Delaware delegates. State legislatures can control what their delegates are authorized to do, and they did so, and they followed their instructions. If you want to quarrel about the Massachusetts and New York delegates, read Federalist 40 and you'll get the official detailed answer of why, even with those 2 states, they followed their instructions correctly. Madison does a really good job. And if people want to quarrel with Madison, let them quarrel with Madison. I don't have time for that kind of nonsense. Now, you've also heard the other form of defamation, that the Founding Fathers rigged the ratification rules. The ratification required approval by 13 states. Instead, they did 9 states. Well, what about that? And that's one of the fear-mongering things you hear about Article 5, is that they can illegally change the ratification process. Here's what happened. Remember that the Constitutional Convention only had one power, that was the power to make a recommendation. And they made 2 recommendations. They recommended the Constitution itself, and they recommended that the people themselves approve the Constitution, because they wanted to understand that all political authority rested with the people. And so they said, we want to have ratification conventions where the people directly choose the delegates to Republican form of government, but it's the people choosing for this particular purpose to ratify or not ratify the Constitution. And so that was their recommendation. To whom did they send it? They sent it to Congress, just as all of their commissions told them to do. All the states that appointed said, after you got your work product done, you send it to Congress, and then they have to send it to the state legislatures for approval after that. That was the standing rule. Not because it was in the Articles of Confederation, but because every state told them to do it. And so it was the same rule as in the Articles of Confederation. It was from a different source. It was from the state instructions themselves. So, true to their instructions, they sent it to Congress. Congress approved both recommendations, both the Constitution itself and the new method of ratification. They didn't send it to the state ratification process because they didn't have the authority to do so. They sent it to the state legislatures who had the authority to say yes or no to the new process. Every state legislature unanimously, immediately, before the Constitution was ratified by the necessary number of states, every state legislature, including Rhode Island and North Carolina, where their conventions rejected the Constitution itself, the legislatures previous to that approved the new process by calling conventions. Rhode Island being a Baptist state, I'm an ordained Baptist pastor, so I can make fun of Baptists because I be one. They held congregational meetings. And so every citizen, every voter of Rhode Island was a delegate to the convention. And they rejected the Constitution by a 10-to-1 margin. Being Baptist, they just contrary. And so so they did. But the legislature of Rhode Island approved the new process. How many legislatures were needed to approve the new process? 13. How many state legislatures approved the new process? 13. Did the Congress approve it? Yes, unanimously. So by unanimous consent of Congress and all 13 states, we changed the new process. And then the new process was used. So they argue that they illicitly used a process that they made up out of thin air is another defamation against the Founding Fathers. And whose interest is this? Well, Warren Burger has written a letter that gets a lot of circulation. Warren Burger, one of the co-authors of Roe versus Wade, who doesn't want to live under have the Supreme Court live under the Constitution as written. He likes the power to make up law out of thin air. If you ever want to read a judicial activism, read the last page of Roe versus Wade, where they say trimester this and trimester that, hospitals can do this, and clinics can do that, and docs. They're reading the word liberty in the 14th Amendment, and they're seeing trimesters, doctors, health clinics. Judges aren't that good at reading crystal balls. The tea leaves aren't there for them to read it. They're making it up out of thin air. They wrote a statute. That's what they did in Roe versus Wade. So Warren Burger, being an enemy of the original intent of the Constitution, is now circulated by conservative organizations promoting this Warren Burger letter, said, well, you could run away. We got to be afraid of this. Well, he's got good reason to be afraid of this process. So we're going to take away his power. We're going to take away the power to have the Supreme Court write laws like they did in Roe versus Wade, and like they did in Miranda, and like they did in so many other cases, where they make it up out of thin air and has no correlation whatsoever to the original Constitution of the United States. It has been the enemies of the Constitution that have promoted this doctrine, and unfortunately some of our friends, people that I know and love and have worked with for years and years and years, Phyllis Schlafly being one of them. Phyllis is a wonderful woman. I've got a thing on my wall where Phyllis gave me an award for being a true hero of the Constitution. She gave my wife an award for the full-time homemaker of the year. I love Phyllis. And both of us would probably say this. I will say it for sure. Phyllis has had an absolutely remarkable career. She's entitled to be wrong on one issue in 50 years. And I think it's this. And she would probably say the thing about me. We've worked together on so many things over the years. And she thinks I'm wrong about this. But she relies on Warren Burger. I don't. And I think we need to, I rely on James Madison. I'll take James Madison over Warren Burger every single time. And so we want to understand, and in fact, Madison said when he watched the government for a long time, he didn't want a second constitutional convention, which is different than an amendments convention. He didn't want a second constitutional convention immediately after the first one. He wanted things to settle down. He said, let's see what the real problems are and then have a convention and not go in prematurely just on some speculation of what might be the problems. In the 1830s, when he had some time to see what the problems were, he said that the best way for the states to override abuses by the federal government is in the Article 5 process. This is true constitutional nullification because it just doesn't make sense for one state to be able to override all the government. I'll give you an example of why that's true. I was the chairman of the group that wrote the Religious Freedom Restoration Act, that Hobby Lobby so far has successfully used to not be forced to support abortions through their health care policy. Now, I named it, and I didn't write it all by myself, I did name it all by myself, and I was the chairman of the drafting committee. Now, if California didn't like that federal law, the Religious Freedom Restoration Act, California can nullify it if we're going to buy into nullification. And they say to Hobby Lobby, well, yeah, I know you're supposed to, that this federal law gives you protection, that you don't have to pay for abortions, but we're nullifying that federal law. You got to pay for those abortions in California. What's good for the goose is good for the gander. If you're going to accept nullification by Oklahoma, you got to accept nullification by California, Massachusetts. And we don't want to live in a country where one state alone can nullify federal law. States, plural, can nullify federal law. States, plural, can nullify federal law. It is called Article 5. That's how we do it. There's only one weapon that works. Now, how's this realistic? It's 38 state strategy, because you have to ratify. It's like a locker combination. Some of you will have mental images that suggest other things when I tell you the numbers, but just stick with locker combinations. It's 34, 26, 38. That's the combination. And so it's 34 state legislatures have to agree to the subject matter of the convention. Once they name it, they're stuck with it. How do we know? Well, Delaware, in the Constitutional Convention, gives you an example. When the state legislature tells you what your subject matter or what your rules are, you got to stick to it. The other reason we know, 400 applications have been filed by states in the history of the country. Opponents of this go around saying, "Oh, we just made up Convention of the States language." It's not a real thing. It's because they don't read history. The very first application under Article 5 was by Virginia. It was passed in November of 1788. It was filed in Congress in May of 1789. They called the process we're talking about in that very first document, calling for a convention of states. That's what the Virginia General Assembly said in 1788. It was good enough for the people that helped to write the Constitution and ratify the Constitution. It's good enough for me. And so, you learn a little history, you can learn a lot. So, it's dangerous to only know a little, it helps to know quite a bit, frankly. So, 34 states have to agree on the subject matter. 400 applications have been held. We've never had a convention. Why? Because there's never been an agreement on the subject matter. The subject matter agreement is an absolute prerequisite for calling the convention. When you have agreement on the subject matter, then and only then do you have a convention. If it was good enough to say we want a convention, we'd have a convention a long time ago. Because, if the subject matter wasn't controlled,